giving a short summary of Jackson's career. But when I got to my hotel room, I saw that the telephone company was ahead of me, and they have a very good summary of what he did and jobs that he held, so that although I had intended to spend about 5 minutes in that part of my remarks, I guess I can now deduct that from the 20 minutes that I promised Greg that I would speak, and you only have to listen to me for about 15 minutes. Well, I recommend that you read the telephone directory.
So does Altel.
I have to start by saying that at the time that Justice Jackson was appointed to the Supreme Court in October of 1941, I had not yet entered my 3-year law school course. I emphasize the 3 years because in many of the things that I have seen written about Jackson, there is a good deal of comment on the fact that he went to law school for only 1 year. It is true that he spent 1 year at the Albany Law School, but he took 2 years of work during that 1 year. And if there is one thing that I learned in the 3 years that I spent in law school, it is that you learn the legal method and the way of legal thinking in the first year, so that the other 2 years are really superfluous anyhow. Turns out, therefore, that if Jackson did 2 years of work, he got an extra year of education and than he really needed, and he demonstrated throughout the rest of his life that it was not formal education which was important, but self-education. He was a man who read continuously. He knew the Bible. He knew Shakespeare, and he got his inspiration in the city of Jamestown, where he spent an extra year at the Jamestown High School after graduating from the Frewsburg High School. Another instructive comment that needs to be made about his year at Jamestown was that he asked the principal at that time, a man named Milton Fletcher, whether there was a course in economics that he could take. And Fletcher was so struck by this young man's interest in economics that he said, well, no, we don't have a formal course, but I'll teach it to you, which he did. It's a very important indication of Jackson's lifelong interest in as many subjects as were available to be mastered. When I finished my courses at law school, or just before I did, Justice Jackson interviewed me and asked me to be his law clerk beginning in June of 1945. I, of course, was delighted, and I'm sure that Phil Neal, who we mentioned, my predecessor, who had also been at the law school with me, had something to do with my getting the job, because like Jackson, I did not apply for it. He made a point in his comments throughout his life that he had never applied for a job, that the jobs had come seeking him. And when he accepted them, he accepted the responsibility, and he performed exceedingly well in each of the jobs that he took. But in my case, Phil Neal apparently had recommended me to the justice. We had both served on the law review together, and as it happened, Bill Jackson was also there at the time and serving with us on the law review. So that I've always suspected that it was not only Phil, but probably Bill who had something to do with my getting the job. What the job amounted to or consisted of was that I was expected to read, summarize, and make recommendations on the petitions for certiorari, or as we refer to them in the cert petitions, which are the applications from the parties for the court to hear a case from a lower court. Of course, as you know, the Supreme Court has a great deal of discretionary jurisdiction. Most of the cases are not appealable as of right, and so it's necessary to petition for review, and there are perhaps 5 or 6 or 7,000 of those every year, and the clerk's primary job was to read those petitions as they came in, to digest them, and to recommend what should be done with them. There was no guarantee that the recommendation would be accepted. The judge, of course, made up his own mind. The one thing that I discovered very early on was that Justice Jackson very, very definitely did his own work. He expected anyone who was his colleague or who worked with him to do the work that he was assigned, but that he himself did his own work. He did not expect the law clerk to write opinions. He never expected his partners in law practice when he practiced here in Jamestown to write his briefs. He wrote his own briefs. He argued his own cases. And of course, he did all of those things supremely well. But I do remember one time he had dropped a draft dissent on my desk, which he did when he finished what he had to write, and when he thought it was ready for circulation among the other justices. He asked for comments, and if he thought the comments were worthwhile, he would adopt them. If he thought they were not, he wouldn't say anything about it. And I read this draft dissent. I thought it was a superb statement, and I went across to his office. The way the chambers were designed, laid out at that time, was that the law clerk's office was on the left, the secretary's office was in the center, and the justice's office was on the right. So I crossed over through the secretary's office and stood in his doorway, because I saw him seated beside the desk, writing on a yellow pad, which is the way he did his opinions. And he was so absorbed that I hesitated to interrupt. And after a while, he raised his eyes and, "Oh," he said, "Yes, what is it?" I said, "Well, I didn't really mean to interrupt you, but I've just read this draft dissent, and I think it's a superb job. There's really nothing I can add to it. I just wanted to tell you what I thought of it." "Oh," he said, "Well, thanks, but as you can see, when I'm writing, I find that very easy to do. It just flows. But it's after I've written it that I look at it and I say to myself, what does it all mean?" And he said, "That's why I need somebody like you to read it and to tell me whether you think it makes sense or whether you have any criticism of it." I said, "Well, in this case, I'm not going to be of any help at all, because I just think this is a marvelous job, and there's nothing that I can do to improve it." There came a time then in the term when he said to me, I guess I'd been there 2 or 3 months, that it was his practice in every term to allow his law clerk to write one opinion, and that he had decided that the opinion that I should write was a patent case. Well, if any of you know anything about patent cases, they're not very thrilling, but they need to be written. And of course, I wrote it, and with a few changes that he made, it was circulated and approved, and I believe it was a unanimous decision. The one interesting thing about it to me was that it overruled the decision of the Second Circuit, which was written by Learned Hand. Of course, Learned Hand was then and always considered to be the premier judge in the country, and particularly knowledgeable in patent cases. But the court decided to overrule him, and that's what we did. I can't claim that I had any input into the decision. All I did was write the opinion. Later on in the term, Justice Black circulated an opinion in a case which involved what I thought was an outrageous situation. Just briefly, I will tell you that it was a suit by a member of a partnership representing a company which had been put out of business by a union. And they had been put out of business deliberately, because during the course of a strike, one of the union officials was killed. And the union charged that he had been killed by one of the partners of the company. He was indicted, but he was acquitted. And the union was not satisfied with the acquittal. So they decided that they simply would not do business with this company. And even though the company was prepared to sign any agreement that they wanted, they refused. and obviously the company went out of business since the major customer of the company was the A&P, and they had an exclusive contract with the union to employ only companies that were unionized by this union. And when the union refused to enter into any contract with the company, it went out of business. They sued under the Sherman Antitrust Act, and claimed that they were entitled to damages because this union activity was not permitted under either the labor laws or the antitrust laws. Well, to make the outcome shorter than this recital has been, Black, representing the majority of the court, decided for the union, that the union had the right to put this company out of business and was not subject to the antitrust laws. I thought that this was an outrageous decision. It was a 5-4 result. Jackson was in the minority, and I told him what I thought about it. He said, well, if you feel that strongly, why don't you write the dissent? And I said, I guess, having absorbed some of what has been called his own impish candor, I said, well, I don't really mean for me to write this because I've already written the one decision that you said you allow a clerk to write. And he said, why don't you do it anyway? And I did. It was circulated, and I believe it was the afternoon, Friday afternoon, before the Saturday conference, in which the final decision is made to hand down decisions, that Byron Cabot, who was Justice Reed's law clerk, called me on the phone and said, congratulations, your dissent has persuaded my judge, and he's shifted his vote so that now your decision will be the majority opinion. Well, I thought that was great. Except that Saturday morning, he called me again, and he said, sorry to tell you, my judge has changed his mind again. And your decision, your opinion remains the dissent. Unfortunately, Justice Reed did have the reputation, well deserved, I think, of shifting back and forth on his votes, so that this was not the only occasion in which he changed his vote. As a matter of fact, in a much better known case, that is the Jewel Ridge Coal Company against the United Mine Workers, which was decided at or about the same time toward the end of the 1944 term. There again, the tentative decision of the court was 5-4 in favor of the mine owners. And Jackson and Reed were on the majority. Chief Justice Stone assigned the opinion to be written by Jackson, but before he got well into it, we got a phone call that said that Justice Reed had changed his mind again. So that decision then became the prerogative of Justice Black to assign for opinion writing, because he was the senior associate justice then on the majority, and he assigned the opinion to Murphy. Well, I don't know how much of that controversy survives to this day, but the Jewel Ridge controversy has been described more or less in shorthand as the Jackson-Black feud. I wouldn't describe it that way myself, but apparently there were a number of columnists in Washington at the time when some of these facts became public, described it in that way. But it is interesting to speculate that if Justice Reed had not once again changed his mind, that decision would have been written by Jackson. It would have been in favor of the mine owners, and the so-called feud would never have seen the light of day, because the feud supposedly erupted 1 year later when Jackson sent a cable from Nuremberg to the judiciary committees of both the House and the Senate, complaining about Black's behavior in that case, particularly in connection with a motion for rehearing, which was filed after the decision came down. So what I'm saying is that if Reed had not changed his mind, all of that would not have happened, because there would not have been any occasion for Black to disclose, for Jackson to disclose what Black had done in that case. And beyond that, of course, if Reed had not changed his mind, the likelihood is that Jackson would have been appointed Chief Justice when Stone died in April of 1946. But let me refer to a couple of other less speculative and perhaps more enjoyable incidents. I remember after he came back from Nuremberg, he came into my office and he said, they want to give me a medal over at the Pentagon. If you want to come along, so I'm going to drive over there. And I said, sure. We got in his car and he drove to the Pentagon, and he drove into the garage and turned off the engine. He said, that takes the cake. He said, you know what I've done? He said, I've driven all this way with my brake on. But he got his medal, and it was only one of many many honors that were given to him after Nuremberg by many universities and many governments. And then I remember that about, it was precisely 10 years after he had been appointed to the court, he was the the honoree at a dinner that was given by his law clerks, all the law clerks who served him in those 10 years. Unfortunately, I could not be present because I was then in Paris with the Marshall Plan, but I was aware of what was happening and joined the other clerks in a memorial gift to him. And I was surprised then, almost immediately. This is dated October 10th, 1951. I got this note from him in which he said, "Dear Murray, all that was lacking to make last Saturday a perfect day was the presence of you and Phil Neal. Of course, all envied you in your new assignment, and if wishes were airplanes, the whole party would have landed on your doorstep. I appreciate your part in it and the gift of the Churchill volumes. He is one of my favorite authors, as much a master of the King's English as he was of the King's government. With thanks and all good wishes, sincerely." Well, as you can see, I've kept that note. It was a surprise to me when I received it, and I was very glad to have it. I think it would be appropriate, I don't know whether I've exceeded my time or not, but
I think we've got time for maybe a few questions, and I'd like to encourage you, if anybody would like to stay on, if you don't have to go off to resume that taping right away, that anyone who's interested might want to come up and visit with Murray and Tom. Can we take maybe a couple brief questions, if any of these current events people have something burning in their mind?
Let me just start off, Murray, why don't you describe his personality?
well, it's very interesting, as I was saying before, earlier this morning. Many people saw him differently, but to me, he was a very friendly, open, honest man, and considerably receptive to anything that anybody else had to say, but obviously he made up his own mind. He was an extraordinary person to work with or for, and he was no question of his brilliance. I mean, he was a great writer, but he didn't act in any pompous or overbearing way. He was just naturally friendly, as I think all the people here are.
Russ?
Aside from Jackson, can you tell us a little bit about the Marshall Plan and will it work again today?
Well, I can tell you a little bit about it from my point of view. I was lucky that when I came over there, the only country with which the United States had not signed a bilateral agreement was Spain. When I got there, I was assigned the area of bilateral agreements. Of course, when I got the assignment, I thought that was great, but after I'd been there a couple of days, I realized that it was meaningless because all the agreements had been signed, and Spain had broken off negotiations because they were not getting what they wanted. At the same time that we were trying to negotiate an economic aid agreement with them, we were also trying to negotiate, or that is the Pentagon, was was trying to negotiate an air bases agreement. And they thought that they could use that as the bargaining chip to get more economic aid than we had given to the other countries. But our people refused to go along with that, so the Spanish broke off the negotiations. And then eventually they said they wanted to resume. Well, I was fortunate enough then to be part of a two-man team that negotiated the Spanish aid agreement. And incidentally, I was called on by the air agreement, that is the tax clause. You may know that the first job that Jackson had in Washington when he came down in 1934 was as general counsel to the Bureau of Internal Revenue. The first job that I had when I started practicing in San Francisco was Air Force team, which consisted of hundreds of people, apparently didn't have a tax expert, so they asked me to help them. That was one personal experience that I had. I think it would take too much time to go through aid to destructive Europe at the end of the war. And one of the things that occurred to me from time to time is that we got very little gratitude for it. I mean, not that we went into it with the idea of gratitude, but the French particularly, as you can see now in connection with the Iraq situation, the French considered themselves, and they considered themselves then, as the premier diplomats of the world, and they looked down on Americans, and I don't think they had any justification for it. And I did my best to make sure that they understood that.
Murray, you know, the Jamestown area is most proud to be the home of Robert H. Jackson, to be the home of the Robert H. Jackson Center, and we're so appreciative of the work that you, your son, and others are doing to not only preserve but to promote the very fine work of Justice Jackson, and we really appreciate you being with us today.
Thank you. Thank you.
As a small memento of your visit for you and for your son Tom, it's our club mug, which is emblazoned with the rotary wheel, which stands for civilization and movement, which are two topics that are not foreign to you. So again, thank you for being with us today.
Thank you very much.